Welcome to On the Ballot with Ballotpedia, where we connect people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed.
Hi, I'm Norm Leahy, your host here on the Ballot with Ballotpedia. I'm a senior editor at Ballotpedia, where we talk about all things related to politics and policy in the United States. Today, we're going to talk about something that doesn't get, and I don't think, enough attention, and that's basically some of the processes that are used to select federal judges. Joining me is someone who is eminently qualified to discuss this, Carl Tobias, a professor at the University of Richmond, right here in my hometown, Richmond, Virginia. Professor, thank you for joining us. Pleased to have you.
Thank you for having me.
And for those who may not be aware of it, for decades, one of the organizations that helped presidents and the Senate get a handle on judicial nominees was the American Bar Association. Can you give us a thumbnail sketch of what the ABA is and how it got involved in vetting federal judges?
Yes, it's an organization of lawyers in the United States, one of the largest such organizations in the world. I think it has over 600,000 members. And since 1948, the ABA Standing Committee on the Judiciary has helped the U.S. Senate discharge its responsibility to advise and consent on the president's judicial nominees. And that tradition has been followed by 7 Republican presidents and 6 Democratic presidents in that time period. The only presidents who have limited access are George W. Bush and President Trump in his first term, and then now in the second term. And Pam Bondi, the Attorney General, just recently wrote a letter that's severely restricted their access to the nominees. And we can go through that process in just a bit. But basically what they do is look at the competence of the people who've been nominated by the president or candidates before, and that's what they did in the past, is actually at the time the president was contemplating nominating someone, they would have access to that person. And so if someone were not very well qualified, then you could avoid the embarrassment of nominating the person and then having to withdraw the person. So that's the role that basically has been played since 1950 or so. At first, they just went to the Senate with Judiciary Committee, which has responsibility for vetting and then sending on people through the process to be confirmed. But they, in the Eisenhower administration and all of the subsequent ones, the committee had played an active role. And what it does is it has 15 members of the committee. They are in each of the appeals courts around the country, I think one in each or so. And what they do is basically vet the candidates by giving them written questions and then, in the best of times, having interviews with them where they can question each of the nominees, and then they get together and assemble all of that information. They usually contact at least 40 lawyers or judges who are familiar with the professional qualifications, their suitability for the bench, but they do not do any vetting of ideology or anything of that sort. And they're just looking at professional competence, integrity, as recognized by their peers in the relevant community.
Okay. And yet, roughly since the Reagan era, this correct? That Republicans in particular have questioned the ABA's, I guess, their partisanship on judges. Is that fair? Is that what the general criticism has been?
I think that's correct. Um, the concern has been, uh, Attorney General Bondi said the concern has been they are much more favorably inclined to um, nominees of Democratic presidents than nominees of Republican presidents. But the ABA president wrote a long letter, 7 pages, to explain um, why her reasons for barring the ABA in the Trump administration are wrong and misguided. Um, the just refuting the notion that they look at ideology, that they're partisan. In fact, he goes into great detail in talking about how the committee goes to great lengths to be completely independent. It doesn't really put forward any people. It only analyzes the people whom the president is thinking about nominating or has nominated. Um, and so doesn't support or disfavor any candidates. It only makes a report, which then goes to the president, goes to the nominee. And in fact, in the process as it worked best, it would go to the candidate before nomination. So if there was something negative, then that person could respond and perhaps convince the committee that um, their decision was inappropriate. And the rankings they give are not qualified, qualified, and well qualified. And so they're a tiny percentage who are found to be not qualified.
And so, okay, this administration has made this determination. You're not going to participate, but that doesn't mean that members of the Senate, the Judiciary Committee, or the Senate as a whole can't solicit the ABA's views. Correct?
Well, they could, but what Attorney General Bondi said was they were going to tell the candidates who were potential nominees not to sit for interviews with the ABA, not to give any information to the ABA about their professional competence, and basically to cut the ABA out of the process. Of course, the Senate and the president uh, can, under the Constitution, and are obligated to have duties um, to vet candidates and to put them through the process. But the only professional organization which has the expertise to help in that process and is independent is the ABA.
But are there other organizations? I mean, in the first Trump term, it was widely reported that the Federalist Society, another association of legal scholars, practicing attorneys, etc., was providing guidance to the administration on judicial picks. But the president has had some strong words about the Federalist Society as well. So, is the administration trying to do something that's completely independent of any outside opinion or influence? Or might somebody that we haven't really heard of be offering that kind of counsel?
Well, that's an entirely different question, but it's certainly possible. Um, for example, there's the Article 3 project, which I think includes Mike Davis as its president, uh, who has been very influential, and there are many others who have helped. But I think none have the expertise and long trust that the ABA has built up over time, um, and I think it is true that the Federal Society has many people who've been active and certainly were active in the first term of the president. Um, and many of their members are now presently sitting on the appellate bench and district bench around the country. Um, because the organization is 40 or so years old, and has been very active and very interested in and contributed many valuable things to the federal judiciary, including its members.
And these ratings and the interviews and the data that the ABA and others might present to both the administration and to the Senate, how much influence do they carry on the entire process? Do they actually make or break specific nominees?
They can. One interesting data point is in the administrations of both Clinton administrations and the most recent Biden administration, uh, those presidents refused to nominate anyone who had a not qualified rating from the ABA. So it was dispositive for them. They made it a point of principle not to nominate those people. In the first Trump administration, there were 10 people who had not qualified ratings, and the president nominated 10 of them, and 8 of them were confirmed by the Senate, often on party line votes.
And you follow nominations, and you have done so for years. And the Trump administration is really only just now getting started with nominating new judges to the bench. They're not as late as some. I think some have waited until midsummer before their first nominees were made. But uh, what do you think of the people who have been put forward so far?
Well, he's only nominated 9 district judges, or named 9 nominees for district court vacancies, and 2 people for appellate court vacancies. And I can give you the data on how many there are, but there are 6 present appellate court vacancies and around the country, for which we have 2 nominees. And then there are 46 current district ones, and then 9 future ones that will come open. So it's a much smaller number. There were over 100 in 2016 when the election was won by Trump. And so he had over 100 vacancies he could fill then. So there's a pretty big discrepancy between that and what he has now. Of course, plenty of people can take senior status on the federal bench when they're 65 and have 15 years of service, and they could retire or die in office, and that would create vacancies as well. So there may be other opportunities, of course, than the relatively small number we presently have.
And what do you think about the phenomenon that I've seen reported in various media outlets about sitting judges who are delaying making decisions about taking senior status because they don't know what sort of nominee is going to come after them? What do you make of that development?
I think there's a fair amount of data that show that increasingly it seems that judges are making those judgments, and some judges would like to be sure that they would be replaced by a president of the same party as appointed them. That's the tradition. It's honored in the breach. At the Supreme Court, I think it is much more compelling and more widespread. To some extent, we see it in the appeals courts. I think we don't see it very much in the district courts, partly because district court judges are nominated and confirmed principally because of their competence to move the heavy caseload at the trial level in the federal system. Appellate judges speak and their opinions govern multiple states usually. And so the idea there is they make more policy. A district judge can bind no one, not even other judges in his or her courthouse. But the appellate court can speak for all of the to all the district judges who must follow the precedent of the appeals court in which they are sitting. And so it's a different kind of dynamic.
So a final question for you, Professor, before we wrap it up here. Without the ABA playing a role in this process, what do you expect to happen? Are we going to be seeing something different in the confirmation hearings? Are we going to have different kinds of questions? Is there going to be a different kind of atmosphere, dynamic going on? How do you think this moves forward?
Well, I think it has been extremely valuable to the country, to the Senate Judiciary Committee, to the president historically, because I think it is a strong guarantee that the person has the professional competence, has the integrity, and the ethical bearing, if you will, to serve on the federal bench. And I think that's all the ABA is looking at and trying to discern. And what you want is the very best lawyers who will be the finest judges when they're making these very important decisions, some of them life and death decisions on the federal bench. And by and large, I think the ABA has contributed substantially to that type of dynamic. So it is rare that you see someone who leaves the bench because that judge is found to have done something improper, ethically or in any other way. And so I think the independence and the quality of the judiciary has been improved. Without that, of course, there are concerns about, for example, the present administration. And I think the present Senate in terms of, if you looked at the cabinet nominees, there was virtually no objection to any of them. And so the same thing could happen with judges. And there isn't much of a check in the Judiciary Committee because, by and large, the votes taken in judiciary so far, if you were to look at the executive branch confirmations, you would see at the cabinet level, of course, just about all were confirmed. And then also in the Judiciary Committee, I think we've seen, for example, with high-level Department of Justice nominees, that there have been mostly party line votes coming from the committee, 12-10, and then on to the floor. I would hope that would not happen with judicial nominees because they have life tenure. It's one thing to appoint someone to the Department of Justice for a short term, and 4 years, and give the person life tenure. And I think that's central to nominating and confirming judges.
Well, we'll be watching this process as it evolves in the weeks and months ahead. And in the meantime, Professor Carl Tobias, University of Richmond Law School, I appreciate you sharing your insights with us on this topic. Thank you for joining us today. We appreciate it.
Thank you for having me.
And I'm Norm Leahy, your host. We'll be back soon with another episode of On the Ballot. And until then, you can catch us on the digital pages of Ballotpedia. Take care.